Hello, how are you doing? How is everything? Hope you're good. Hope you're fine. Welcome to another great session. It's a pleasure to create content here. I hope you're doing well. I hope you're staying safe. So today we're looking at when the court becomes Functus official. We're looking at the general rule and the exceptions. Yeah, you as a lawyer or a law student might have a reason to come across issues like this. So you need to know how to respond, how to go about it. When a court gives its decision, can it come back to revisit the decision? Now, the principle of functus official, you know, provides or is being you know which one will I use? I will just say that the principle of functus official means that when a court gives its decision, it cannot come back to what to revisit it. It cannot come back to alter its finality. It provides finality to what judicial decisions. Now we are not looking at that is what the general rule provides. Now we're going to look at the exceptions. Are there circumstances that will warrant or make the court to come back to revisit its decisions? If you're yet to subscribe to this channel, please do hit the subscribe button, share the video, and like it. Drop your comments, your questions, we will attend to it. This is Lawyers Info Hub. These are only two ways to contribute to the growth of the legal profession in Nigeria, in Africa, and beyond. If you're glad to join us, please do hit the subscribe button and also share to your friends. They might learn one or two things from the channel. So, as I earlier stated, that the rule of Functus official provides the final that the courts, once it gives its judgment, it cannot come back to alter what it has ordered. Now, especially if it's a decision on the merit, the court is stripped of all its powers to what to revisit, alter, or change this decision. That is why before judges, before they make their decisions or they deliver their judgments, it's assumed or it is expected of them to thoroughly, weigh the issues and also bring them come to a final conclusion, because they know that once that conclusion has been delivered as a judgment, revisiting it uh, is only possible in very in some circumstances, not all circumstances. So today we're looking at the general rule and what the exception. The essence of this rule of Functus official, helps to preserve the sanctity of the court, so the court cannot appropriate and reprobate at the same time, so that the court cannot sit on appeal over its what own decision. Now, what are the exceptions? Now, a court is entitled to revisit its decision or order that it made in some circumstances. So we're going to look at the circumstances. One, where there is an accidental slip or omission in the decision or the order. Accidental slips in typographical error, where maybe the court is supposed to say defendant and the court says claimant. Where there's arithmetical errors, maybe the court is supposed to calculate some sums and the court made a mistake in its calculation. The court can revisit that judgment and alter that arithmetical error to conform with the right results. So when there is an accidental slip, omission in the decision, the court can come and what revisit the judgment, the decision, and what make effect the correction, so as to give effect to the true meaning and intention as what's envisaged. But in correcting these accidental slips or error, the court will not change the substance or tenor of the decision. Very important. Take the case of a Shishe against Nikon Hotels Limited, the 2017 All Week Federation Weekly Law Report, Part 3, 881152 at 1162. Now, another instance where the court can revisit its decision is where there is need to make supplementary or ancillary orders. Sometimes in a judgment, you see that there is need to make an ancillary order or a supplementary order. The court retains jurisdiction to entertain supplementary or ancillary matters that will help enforce or realize this decision. If the court made a decision or gives a directive, and there's something to be done to realize that direction, or to help that course direction to be, to come alive, or for it to be fulfilled. The court can make supplementary or ancillary orders to that effect. It also includes this right to make supplementary or ancillary orders, also includes the jurisdiction to order for payment of a judgment sum, either by instrumental or to stay the execution of the judgment. You see, once a judgment has been delivered, a party can come back to that court to say, apply for stay of what judgment, or for stay of execution of that judgment. Such application can still be entertained by that judge who delivered that judgment, or stay of execution, yes, of the judgment, pending appeal, or depend, or the person who is owing, if it's a monetary judgment, can say, okay, my lord, please, I want the judgment not to be restructured to be paid. The person can bring an application, such application can be entertained to say, I want to be paid instrumentally to until I offset the judgment debt or the judgment sum. So such applications can be what entertained. It's very, very important to understand these instances, so that when, for example, a party comes back after a judgment has been delivered, asking for some certain things, you now ask yourself, does it fall, these things this party is praying for, does it fall under the exceptions? When the court has an inherent power to set aside its own decision, yes, the inherent power of the court to set aside its own decision will be invoked in what exceptional circumstances. Just like earlier, in exceptional circumstances, when there is a miscarriage of justice, for instance, where the decision is obtained by fraud, deceit, or there's some concealment, suppression of facts. If another party can bring it to the knowledge of the court, my lord, these things were concealed, this judgment or order was obtained by fraud, by deceit, by one of the parties. The court can look at it, and if a court, feels this this is fact that was supposed to be made open, or was supposed to be, bring to light, was concealed just to get the uh, judgment or the order, the court can also, by its inherent power, refute it, that decision, because it's assumed that parties before the court must be all honest in all they do. Well, when the decision is given in the absence of jurisdiction, where the court does not even have jurisdiction, you know, to even entertain the matter, to entertain the suit, when the court does not even have jurisdiction, you know, so the court can set aside such decision it made, or it gave out, or the judgment delivered without jurisdiction. Where the procedure that was adopted, was such as to deprive the decision of the character of a legitimate adjudication. Now, this particular issue, a lot of people have made their comments, a lot of arguments have been there, you know, because it depends on the peculiarities of each case, and the ability of a counsel to be able to substantiate the allegation of what illegitimacy in adjudication process, and seeks to what sets that aside. That's what we call the adjudication process. If there's an illegitimacy in adjudication process, where, for instance, the procedure the court entertained in reaching that decision was an unfair adjudication process, was not known to law. If party can bring it to light, court can what? Revisit its decision and set it aside. Where there is also similar to where there is what? A fundamental irregularity in the proceeding. Fundamental irregularity, it vitiates the decision and renders it what? A nullity. It's very important to understand these things. When people say a judgment was obtained by fraud, you must also list the particulars of fraud. What made it fraud? If you are saying this decision, there was concealment or suppression of fact, you must outline what the real fact is and what was suppressed. So at that point, you have to be very open. You must to be able to change the court's mind, or to make the court know that, this decision you gave, we're not supposed to give it. Then you must do due diligence. You must highlight your point and argue it very well. For the court to waive is the rule of Functus officio, to revisit his decision, to either set it aside, or to declare it a nullity. So these things are listed and very, very key, very, very genuine. As much as we have the general rules, we also have the exceptions. Yeah, I just hope you'll be able to learn something from this video today. There are a lot of cases on this issue when a court can revisit its decision, when a court can revisit its judgment. It's very key because there are instances because of your side, what will be your objections, what will be your response in your accountability. There's a motion for court to revisit or for the court to set aside is the decision earlier given. So you must know, does the argument of this person who is seeking for this application, does it fall within the exceptions? And you who is saying no to it, what are you going to, what are your submissions to counter the the submissions of the applicant in this instance? So you must understand these rules and know when it can work and when it cannot work. So friends, I just hope you've learned something today. I wish you well in all your endeavor. Know that you can always be the best. Keep doing what you're doing, the right thing, not the wrong thing, and believe that you can be the best. Work on yourself. Be diligent. Be resilient. Be hardworking. Be honest, and fortunes will smile on you. Yes. It's a new season. It's a new season. It's a new um, time. So just do all that you can to keep improving yourself. When you improve yourself, you become a better person. Do take care of yourself. Bye for now.